Bismillahirrahmanirrahim. This is the first news on 14th February, newspaper front page dawn. Isa asks why CJP order shared with media not him. Right to Supreme Court Registrar, copies dispatched to all apex court judges. Order bars him from hearing matters involving Prime Minister by Nasir Iqbal. Islamabad, Justice Qazi Faiz Isa on Saturday created quite a stir when he questioned why the February 11 order, in which he was barred from hearing matters involving Prime Minister Imran Khan, was not shared with him before releasing it into the media, terming the entire episode shocking. In a one-page February 12 letter to Supreme Court's Registrar Khwaja Daud Ahmad, on his letterhead, Justice Isa inquired why the order judgment in the rupees 500 million uplift funds distribution among PTI legislators case was not sent to him, and why the settled practice of sending it to the next senior judge was not followed. The copies of the letter were also dispatched to the Chief Justice of Pakistan, Gulzar Ahmad, and all the judges of the Supreme Court. Justice Isa went on to question why was the order released into the media before he read it, let alone had the opportunity to sign it in agreement, disagreement, and who ordered its release to the media. Though the media went frantic with the development, an eerie silence descended soon after the letter was written to the registrar, pointing towards a brewing storm having the potential of getting ugly and tarnishing the image of the judiciary. A number of senior counsel, when approached, preferred to watch the entire episode from the sidelines than openly commenting on the development. However, they somehow were united in saying that whatever was happening wasn't good for the judiciary. They believed that the February 11 order was the outcome of something that happened outside courtroom number one when the funds distribution case was disposed of. They were also remembering the 1997 events when the entire country witnessed how the Supreme Court was divided into two with issuance of two separate cause lists, one under the directives of the then Chief Justice Sajjad Ali Shah, late, and the other from the former Chief Justice Saiduzzaman Siddiqui. The then Chief Justice Sajjad Ali Shah, however, had to succumb under the pressure when a 10-judge bench of the Supreme Court in the Malik Asad Ali case eventually removed Justice Shah after it ruled that it would be wrong and unjust to choose a junior judge and put him at the top as just Chief Justice in violation of the principle of seniority, which has to be followed strictly in case of appointment of the Chief Justice in accordance with the provisions of the Constitution and in consonance with the well established constitutional conventions. Likewise, when our three-judge bench, headed by Justice Shah, had suspended a 13th Constitution amendment through which the President's power to dissolve the National Assembly by invoking Article 58(2)(b was clipped, a larger bench of the court instantly suspended the order of the minority order. Meanwhile, the court roster issued for the week commencing from February 15 assigned only a chamber work unto Justice Isa, though five different benches had been constituted to hear a number of cases during the entire week. In his letter, Justice Isa asked the Supreme Court registrar to provide him the case file so he may finally read the order judgment. It is a normal practice that after the judgment is authored by the member of the bench in the whichever case, and the same is circulated to all the members of the bench to read, and if a member of the bench intends to add or differ with the reasoning cited by the author judge, he issues his additional note on a dissenting note, said a senior counsel who wished not to be named. On February 11, Chief Justice of Pakistan Gulzar Ahmad, while hearing a five-judge bench, had issued an order requiring Justice Isa not to hear matters involving the Prime Minister, considering that he had already filed a petition against the Prime Minister in his personal capacity. The order had stated that to uphold the principle of unbiasedness and impartiality, it would be in the interest of justice that Justice Isa should not hear matters involving the Prime Minister. It had also recalled how Justice Isa, during the hearing, placed on record photocopies of certain documents reportedly received by him from some anonymous source through a WhatsApp message, the copies of which were also handed over to other members of the bench as well as Attorney General for Pakistan Khalid Javed Khan. Though Justice Isa had observed that he was unsure of the documents were genuine, the AGP had submitted that since the authenticity of the documents was questionable, the same may not be taken on record, but in any event, Justice Isa would become a complainant in the matter, and in that capacity, it would not be appropriate for the judge to hear the matter. The Chief Justice, therefore, observed that in these circumstances it would not be proper for the judge to hear the matter. In his letter, Justice Isa stated that he had learned that an order judgment, don't know which one, was passed in the subject case on February 11 and released to the media. This is shocking since as yet I have not received the file which the order judgment the letter said, adding that Honorable Justice Ijazul Ahsan apparently received it, but I never did, and the world knows of it before I have seen it. A member of the Pakistan Bar Council, Munir Kakar, from Balochistan, whoever described the ban on Justice Isa as violation of the 1989 Supreme Court judgment, in which it was held that one set of judges of a constituted bench could not issue a directive unto the order to the other set of judges or any of the judges of the bench not to hear a matter. While dealing with the issue of bias, former Judge Abdul Qadir Sheikh, a member of the then 12-judge Supreme Court bench, had held that one judge of the division bench cannot direct other benches of the bench other judges of the bench not to hear the case on the ground that he has a bias or an interest in the case or for that matter on any other ground whatsoever. Justice Issa has always been in the media glare. Earlier, he surprised many by writing letters to President Dr. Arif Alvi with a request to provide the copy of the residential reference instituted against him for allegedly acquiring um, properties in the United Kingdom in the name of his wife and children. The reference, however, was quashed by a 10-judge Supreme Bench on June 19, 2020, though it directed FBR to conduct an inquiry and then place its findings before the Supreme Judicial Council, which may proceed against justices if they decided to. On June 17, 2020, Justice Issa again created history when he entered courtroom number one as a messenger of Sarina Issa, his wife, to seek an audience for her via video link and satisfy the Supreme Court's 10-judge bench about the source of the three offshore properties in her and her children's name. Shocked, the Supreme Court then had reminded the petitioner, a sitting judge, that they had complete respect for him, but it was not appropriate when the message could have been conveyed through his counsel, Munir A. Malik, as the judge may be overcome by emotions. And in the end, the formal request, if you have not yet, please subscribe our channel and press the like and bell button and to get the fresh from us. Thank you for watching. Have a nice time. Goodbye.